Now I'm proceeding to my topic. It is actually the commitments or commitments in IP related cases, the interplay between EU competition and intellectual property law. So actually we are dealing with the two legal disciplines or two legal fields, namely the competition law and from the other side the IP law as a different legal area. So when we are talking about these legal disciplines, we have firstly, it comes with divergent paths through the history. So we have, when it comes to the competition law, we have that national approach. Specifically, it is important to mention the US antitrust law and law. When we are dealing with the IP law, it is actually less or more universal approach to the conventions and treaties that actually established this legal discipline. Now we are proceeding to their mutual relationships. So we have traditional and modern approach. So when it comes to the traditional approach, it is more giving a kind of main role to the competition law that is penetrating or interfere inside the area of intellectual property law, but there is changes with the development of technology, with innovation, and kind of adopting of a modern approach that actually keep the interests of both of these legal disciplines and taking a balancing approach when it comes to competition and IP area. So we are now approaching to goals and means or mechanisms for achieving these goals. And we have actually some authors that say that we are talking about the different goals. So we have to implement different means, but what is sure that we have some of the same goals that is relevant for both of these legal fields, and that is actually some kind of efficiency of innovation and keeping some good things for both the society and the undertakings concerns, even if we have exclusionary nature of IP laws and more inclusive nature of competition law. So it is for sure that we now have a clear situation that the competition law apply in the IP area, but it is still debatable about the border or the exact lines of implementation of competition law inside this area. So we can see from the literature about different perspectives when it comes to implementation of competition law in IPR field, and also that kind of balancing approach as I mentioned previous. Now I'm approaching to my core of the topic. It is commitments. So this institute is actually derived from the competition law inside the European Union. Now we are dealing with the articles of Lisbon Treaty 101 and 102. Actually, the first one is dealing with the restrictive agreements and practices, and the second one with the abusive behavior or abuse of dominance or dominant position of undertaking or undertakings concerned on the market. When it comes to the commitments, it's a procedure actually legalized or formalized with a regulation, as you can see on this screen, that actually deals with a procedural framework of EU competition law. And we have two procedures, namely infringement from the article or derived from the Article 7, and the second one, what is more important for our presentation, is Article 9, dealing with the commitments. So some kind of informal commitments actually existed even before this regulation and its adoption, but it wasn't formalized in that way that it can be established on a legal basis. So it wasn't so strict procedure at that time. when we are dealing with this Article 9, we can say that it is applicable to different sectors of the economy, also including IP sector as a specific technological also area when it comes to the modern times. We can talk about the benefits or positive and negative aspects of this procedure, because some of the positive aspects are that the undertakings concerned actually avoid finding an infringement and potentially imposing the fines from the side of the Commission. It also didn't lose some kind of reputation or that image of good undertaking on the market when it comes to their competitors, when it comes to the consumers. And also some of the negative aspects of this procedure is the strong position, wide margin of appreciation or wide discretion on the side of the Commission, and it is also under the critique through the literature. Now we are coming to the IP area. So we can say that the Commission frequently applied this instrument in IP cases, and actually it is worth to mention that in the first 5 years from the adoption or formalizing this procedure, we have almost half of all commitments that are made are actually related to the IP area. Then we have a questionable position of holder of IP right, especially when it comes to the competition law and its part of dominant position and potentially abuse of that position on the relevant market. So we have to carefully approach this question and to examine on case-by-case basis. So it's very dangerous to have some kind of generalization when it comes to assessing whether the undertakings concerned that held some kind of IP right actually abuse its dominant position or that derives from the exclusivity of IP right. And from the case law, we can see the formulation that the exercise of an exclusive right linked to IPR may in exceptional circumstances involve abuse of Article 102. So we don't have automatically that the holder of an IP right actually abuse its dominant position, but only in exceptional circumstances, as it was clear from the case law. It is very fruitful case law when it comes to the competition authorities inside the European Union. So now we are approaching some of the known cases. First is Microsoft case. It is relevant because the first case dealing with Microsoft is that the Commission find an infringement and imposed the fine of, you can see that amount of financial burden that Microsoft take from 2004. After that, we have Microsoft that brought case before the General Court, or in that time we have Court of First Instance, and the penalty that was the largest till that time. After that, we have Intel that was actually imposed the highest penalty on that undertaking by the Commission for non-compliance with this decision. So when it comes to the second procedure dealing with Microsoft, it ended up with the commitments made by this company. First, there were concerns about the tying, that practice that the Commission found questionable and that Microsoft implemented through its practice. And Microsoft decided to voluntarily actually commit itself for some remedies. And you can see these remedies, and also what is important that each commitment is under a limited period of time. And there is a possibility of reviewing these commitments on a request of undertakings concerned or on Commission initiative. And you can see that Microsoft actually, through the years, didn't comply with its commitments. So the European Commission imposed fines for this company in 2013. Now we are dealing with a case law. I actually deliberately choose these cases because these are very similar in factual background, these cases, but they ended up with different procedure. So the Motorola cases ended with the infringement decision, and Samsung actually offered for the similar, as I said, factual background commitments, or it commit voluntarily to impose some of the remedies to meet competition concerns. So Motorola cases in Motorola is actually found that infringed and actually abuse the dominant position on the market. It's specifically dealing with the SEP, or standard essential patents, and injunctions that actually this company seek and enforce before judicial institutions against the Apple company. So both of these cases are dealing with injunctions and SEP when it comes to these companies and their actually a relationship with the Apple. No fines have been imposed in Motorola case. Even commission found actually that Motorola infringed because there was no existent case law at that time, and it wasn't the first time that the commission didn't impose the fines because it wanted to establish this case law. And from the other side, as I mentioned, the Samsung actually ended with the commitments. That is a licensee that indicated willingness to enter into a license agreement that must be on the friend terms, or fair, reasonable, and non-discriminatory terms for that licensee, and also for the IP holder, especially the patent holder. Now we are dealing with a case that is not actually closely related with the IP area, but it is very important for the whole commitment structure. So we have De Beers, the largest diamond supplier, and another undertaking, it is Alrosa, a Russian company, as a diamond producer that have commercial relations with this first company, or De Beers, namely. So we have competition concerns, and the commission brought two actually separate investigation, one dealing with the Article 81 in that time, or as we said, restrictive practices or restrictive agreements, and the second one dealing with the abuse of dominant position. So this case was actually ended with the commitments made from De Beers company and commission. And Rosa wanted to challenge this commitment because the whole commercial relation between these two companies are under the question with this commitment decision made by the commission. So the case was brought before the general court, which decided actually that this commitment actually produced a direct and immediate effect for Alrosa. Even Alrosa, as I mentioned, wasn't part of a commitment decision. It was only De Beers and the commission. And the general court actually implemented the principle of proportionality and said actually that for both the infringement procedure and the commitment procedure, we have the same principle of proportionality that applies. This didn't satisfy the commission, so the case was appealed before the Court of Justice in 2010. That actually brought very different judgment opposite to the general court opinions. And it said actually that we have a different principle of proportionality when it comes to the infringement procedure, and different applicability of this principle when it comes to the commitment decisions. So the general court main finding is that it is necessary to take into consideration the interests of third parties, but the Court of Justice said that this judicial review for its parts relates solely to whether the commission assessment is manifestly incorrect. So this case was the first case where the commitment decision was brought to the judicial institution. And finally, we are approaching to the case that is a fresh case, that is new case. It is Canal Plus case. From the December, we have decision of European Court of Justice. First, I want to say something about the factual background. There was actually, from the one side, Paramount company as a part of film studios. So we have a lot of companies with a similar factual background, but we are dealing in this case with a Paramount company. And from another side, we have pay TV broadcasters. So this case directly deals with the IP area, IP law, especially with the copyright. So we have on the side of pay TV broadcaster different European broadcasters such as Sky, United Kingdom, Group Canal Plus from the France, and these companies like film studios and pay TV broadcasters were under the license agreements for broadcasting the audiovisual content. First, in this case, we have a Commission and Paramount commitment decision. It is dealing with the possible competition concerns with the restrictive practice. So this kind of commercial relationship between film studios and broadcasters are under scrutiny of restrictive agreements or license agreement that is actually territorial exclusive, or it has geo-blocking clause that was problematic under the Commission opinion. We have investigation from the side of Commission, the Commission, and statement of objection, and actually this ended up with this commitment decision. After that, the case was brought before the General Court, which actually was raised by the group Canal Plus, that actually argued that we have cultural diversity and IPR that justify that territorial exclusivity in these licensing agreements, and specifically that this commitment decision is overbroad or overstretching from that what is necessary to meet the competition concerns. But the General Court actually rejected these arguments by the Canal Plus, and actually it upheld the Commission position and the commitment decision made by the Commission. Canal Plus wasn't satisfied with this decision, and the case was brought before the Court of Justice. And some of the authors, after the judgment was brought, actually cited that we have revisited Alrosa, but actually not all of the commentators specifically dealing with this case are actually ready to say that we have revisited Alrosa, because we are dealing with a different factual circumstances. And what is important for this judgment of Court of Justice is actually that we have for the first time that the commitment decision was actually annulled. So it is important for the case law. And as I mentioned in the beginning of my presentation, we have that concerns that Commission actually has very powerful methods when it comes to commitment decision and strong position. So for the first time, we have effective judicial control or judicial review when it comes to the commitment decision made by the Commission. And the possible consequences of these decisions can be actually the smaller number or filtration of commitment decision, because Commission usually use this commitment decision instead of infringement procedure. We can expect that it will be more precautious when it comes to making such binding commitments, and we can expect to take into account the interests of third parties more than it was case before. So it's not only the question about the Commission and undertakings concerns that voluntarily propose the commitments, but also the interests of third parties outside that commitment decision, but having direct or immediate effect on the rights of that third parties, and specifically precaution when it comes to assessment of the principle of proportionality. So these are actually the conclusion. We have some kind of different levels of interplay when it comes to the competition law and IP law. Firstly, we have a material law that is consisting of different or maybe similar in some main goals. The second level of interplay is a procedural framework. So as I said, we have, when it comes to the competition law infringement procedure and this more flexible commitment procedure, we have abundance of commitment decision in IP-related cases, but it is questionable from this case, Canal Plus, actually, is it a turning point when we will have smaller number of commitments or more precautious approach of the Commission when it comes to this procedural framework, and also having in mind the principle of proportionality and specifically rights of third parties. So thank you very much. I'm very glad to hear some of the questions and to have a fruitful debate after.